Hi everyone, my name is Shazia Khan, and today's unit that we'll be doing is contract law, principles of contract law, and the learning outcome we'll be doing today is learning outcome 3, which is to understand the principal factors that vitiate a contract. Before I go into learning outcome 3, I just want to give you a little overview of what we did in the last learning outcome, which was learning outcome 2. In learning outcome 2, we looked at elements of a valid contract. So we looked at offer, acceptance, consideration, intention to create legal relations. We looked at the terms of a contract, terms implied by custom, trade, and usage. We also went to look at express methods and methods of incorporation, and we looked at a really important case in regard to that, which was the case of Lay, Strage, and Grobo. We also looked at conditions, warranties, and inanimate terms. We looked at cases such as Poussard and Spears and Pond, 1876, and the Hong Kong Fire Shipping and Kawasaki Keisha, 1962 case. We also looked at contractual duties on breach of terms and exclusion clauses, limited clauses, and operation of these in business. We also looked at statutory express terms and what they were, and looked at the statutory governance of exclusion clauses. We looked at the Unfair Contract Terms Act 1977, which is referred to as UCTA, and looked at their key provisions and looked at cases with reference to that. We also looked at the Consumer Rights Act 2015 and the key requirements for that act, also with reference to cases as well. Throughout the Learning Outcome 2, we looked at legal cases, case examples to back up certain concepts. We also looked at representation and how it's different from a term, and also the different factors courts consider in determining whether it's a representation or a term. And we looked at, in regards to that, some important cases like the Bannerman and White case, 1861, and the Dick Bentley Productions Limited and Harold Smith Motors, 1965. We then went on to look at express terms and methods of incorporation. Again, looking at the important case of Lestrade Grogan and Sperling and Bradshaw. We then looked, as I mentioned earlier, terms implied by custom, trade, and usage, and looked at how terms can be applied in common law, how terms can be implied in fact, and looked at cases like the Moorcock case, 1889, and Shaw Law and Southern Foundries, 1939. We looked at terms implied by law, and we gave some examples of the landlord and tenant agreements and the sale of goods contracts in regards to that, and looked at the cases such as Liverpool City Council against Irwin, 1977. We then went on to look at the distinction between terms implied in fact and in law, and looked at limitations on implied terms. We then went on to look at the element of how terms can be incorporated into a contract, such as express terms and terms incorporated by notice, terms incorporated by conduct, and terms implied by law, and looked at the Consumer Rights Act 2015 and Sale of Goods Act 1979, and looked at the Sperling and Bradshaw case in regards to terms incorporated by conduct. We then went on to look at elements of contract conditions, warranties, and inanimate terms, and what each one was with reference to cases. We also looked at the discharge of remaining contractual duties on breach. And we went on to evaluate the validity of exclusion clauses. We looked at what exclusion clauses were and limitation clauses, and looked at the operation of exclusion clauses and limitation clauses in a business. So we looked at incorporation by agreement or control under common law, and looked at the cases such as Parker and South Eastern Railway, 1877, and Houghton and Trafalgar Insurance, 1954. We looked at statutory clauses on exclusion clauses, statutory control, sorry, on exclusion clauses. And we looked at the Unfair Contract Terms Act 1977 and the Consumer Rights Act 2015. And we looked at the element of evaluation of validity, so strengths of exclusion clauses. And we also looked at things like weaknesses of exclusion clauses and how they impact on certain contracts as well. So this was a quick overview of what we've done in Learning Outcome 2 on principles of contract law. Now we're going to move on to Learning Outcome 3, which is today's session, and that will be on understanding the principal factors that vitiate a contract. So the indicative content is to look at capacity to enter into contractual relations. We look at minors, contractual capacity and contracts when necessaries. We look at intoxication and intention to create legal relations. Meeting of the minds requirement, contracts void on public policy, including prenuptial agreements. Statutory illegality. We look at misrepresentation and we look at the different types, fraudulent, innocent and negligent. We look at the Misrepresentation Act 1967. Mistake, different types of mistake, common, mutual and unilateral. The effect of mistake on a contract and the remedies available to the innocent parties. So what happens if there's a mistake made, what remedies are available? Duress and undue influence and frustration of a contract. So key terminology for Learning Outcome 3, what are the contract vitiation factors? And these are elements that can be invalidate or nullify a valid contract. So, you know, these are when present, they can render a contract void or voidable, allowing affected party to rescind the agreement or seek remedies. And the main vitiation contract includes, like we mentioned earlier, which we'll be going through, is misrepresentation, mistake, duress, incapacity, and illegality. And we've just gone through mistake, misrepresentation, and duress just for an example for you. So misrepresentation can be, like we said, classified in three types: fraudulent, negligent, and innocent, which we'll look at more detail later. A mistake can be categorized in mutual, unilateral, and common mistakes. And then duress can take forms of physical threats, economic pressure, or other intimidation. So we'll look at them in more detail. There's a video there that you can look at in your own time, and that looks at vitiation factors within contract law and what elements that plays when it comes to identifying any sort of breaches or anything. So understanding the element of the principle that may vitiate a contract. So, you know, a contract can be defined as a promise or a set of promises which the law will enforce. The agreement will create rights and obligations that may be enforced in courts. However, there are situations where parties have reached agreement, but the question arises whether the existence of non-existence of some fact or the occurrence of non-occurrence of some event destroys the basis upon which the agreement has reached, so the agreement is discharged or in some way, other way vitiated. And there's, like we said, 5 main factors that could do this: mistake, misrepresentation, duress, and undue influence and illegality. And we'll go through them in more detail so you've got a little bit of an idea what each one covers. So like we said, factors that vitiate contract. The first one is a mistake, which is an incorrect belief by one or both parties regarding a fundamental aspect of the contract. The effect on the contract: it may render the contract void if the mistake is material or fundamental. Misrepresentation is a false statement of fact that induces one party into an agreement with another. And the effect on contract is the contract may be voidable, allowing the injured party to rescind or claim damages. And then we've got duress, which is coercion or threats to force a party to get into a contract. And that happens if the mental capacity is not right as well. The effect on contract is voidable. Undue influence is manipulation from one party to another of trust or dominance, and the effect on contract is avoidable if undue influence is proven. And then illegality: contracts for legal purposes and those violating any sort of public policy. The contract is void and unenforceable. So mistake. So let's go through each one so you've got a bit of an idea what each one covers in regards to it. So in contract law, one of the parties holds one of the two parties holds a wrong belief before entering into a contract, which is mistake, constituting a mistake. It is worth keeping in mind that the definition of mistake is technical and carries a specific legal meaning. The mistake may be about the identity of the other party. It may be subject matter of the contract can lead to a mistake. If, for example, you believe you are purchasing free-range eggs, but you actually received caged hen eggs. Terms of the contract, for example, if you thought you are paying in a monthly installments, but instead you are paying in weekly installments, and the nature of the contract. Over time, English common law has refined the rules on mistake. Each negotiating party has an obligation under English law to refrain from deceiving them into signing a contract. In most cases, it's not legally necessary to disclose all information during discussions, but you must be careful not to give false information. A contract could be voidable even if in the case of an innocent mistake. Avoidable means it is unenforceable. So we've got different types of mistakes. You've got common mistake, you've got mutual mistake and unilateral mistake. So common mistake is the type of mistake is a common mistake occurs when both parties are mistaken about the same aspect of the contract. The shared mistake must be about something that is a serious aspect of the contract. It cannot be something that's not sufficiently serious. For example, imagine you enter into a contract to buy a piece of equipment. Additionally, you and the other party did not realize that equipment did not work. In that case, this is likely to be sufficiently serious common mistake. In such situations, the court might determine that the parties did not create a contract at all. Alternatively, the court may decide that the parties created a contract, but it's void, making it a voidable contract. And the case in regards to the common mistake is the case of Bell and Lever Brothers, where a mutual mistake must be about redundancy agreement, did not void the contract because it did not affect its core purpose. The next one is mutual mistake. And a mutual mistake is when both parties are mistaken about different things within the contract. This is sometimes referred to as when parties are cross purposes with another. Sometimes this can be where the parties have misinterpreted the contract. A contract is unlikely to be declared void if both parties made a mistake regarding the content of the agreement. If there's only one interpretation of what was agreed upon based on the words and actions of the parties, the contract will still be enforceable. In this type of situation, a court might find there is only one interpretation of the contract which would have been reasonable. If this is the case, they will still have a binding contract. However, it is not possible a court may find that there's a voidable contract, which means that the agreement may not amount to legally enforceable contract. And the case in regards to that is the case of Raffles and Wichless, 1864. And the final type of mistake is the unilateral mistake. This is where one party is mistaken and the other party should have known about the mistake. And the example here is suppose two people enter into a contract. One party is mistaken about an important term of the contract and the other person is aware of this. In this case, a court will only often decide that there is no legally binding contract in the first place. A court will usually insist that there must be a meeting of the minds for a contract to arise. However, if one party makes a mistake about the facts of the contract, the situation is different. For example, if a person thought he was buying a vase from 1750, but the vase is from 1790, and the seller knows this, the contract might not bind the buyer. This only applies if the seller is aware of the buyer's mistake. It's worth noting that in cases of unilateral mistake, the courts may be more inclined to void the contract if there's evidence or unconscionable conduct by the party who is not mistaken. So, in that instance, they are allowed to change it. The next one is in regards to elements of voiding a contract is misrepresentation, and misrepresentation occurs when one party provides any sort of misleading information that influences the other party's decision-making process, causing them to enter into contract they would not have otherwise agreed to. So it's important to know that it will occur unintentionally or deliberately and can be grounds for contract termination, legal action, or compensation. There are three types of misrepresentation. We've got negligent misrepresentation, fraudulent, and innocent misrepresentation. So fraudulent misrepresentation, this is where a party making the statement knows or believes it is untrue or has a reckless disregard for its truth. The claimant does not need to establish motive for dishonesty. However, they must provide the defendant did not honestly believe that they were saying was true. Fraudulent misrepresentation stems from the tort of deceit. The courts have to obviously determine the following 4 points to establish that deception did occur. So the first point is that the defendant makes a false representation to the claimant. Secondly, that the defendant knows the representation is false. Alternatively, they are reckless about whether it's true or false. Thirdly, that the defendant intends the claim should act in reliance on it. Fourthly, that the claimant acts in reliance of representation and consequently suffers loss. And that is an example in the case of Derry and Peake, 1889. Then the next one is negligent misrepresentation. And the Misrepresentation Act, 1967, defines negligent misrepresentation as a statement made by one contracting party to another carelessly or without reasonable grounds for believing it's true. There's no requirement for the claimant to establish fraud, and the test for negligent misrepresentation is objective in this case, okay? Negligent misrepresentation differs from negligent misstatement, the latter being action in tort, which may be invoked with or without a contract being in place. An action for negligent misrepresentation can only arise within contract law. So the next one is innocent misrepresentation. And here, misrepresentation made without fault. So where the person making the statement can prove on the balance of probabilities that they reasonably believe that their statement was true. So, that's, innocent misrepresentation. The next one is duress. So duress is a contract signed under duress might involve threats, such as blackmail or even violence to persuade one party to sign the contract. So it could be any sort of harm as well. There may be different circumstances in which duress involved in the signing of a contract, including threats to property, destruction of property, for example, persons or businesses. You have economic threats, and the threat here is to damage a business or person financially, and it's a common form of duress, and the court will consider each case involving duress according to its individual circumstances. So they will take that into account. And the case in regards to that was the case of Atlas Express and Cafco, 1989, where it looked at economic pressure forced a small business to agree to unfavorable terms, rendering the contract voidable. The next one is undue influence. Undue influence occurs where a person uses their power or authority to unfairly influence another person's decision. So it's dominant over the party. The validity of the legal agreement or document can be affected by undue influence, as it can deprive a person of their free will and consent. In some cases, undue influence can also amount to a criminal offence such as fraud or abuse. There are two types of undue influence: actual and presumed. Actual undue influence is when a person is subject to direct pressure or coercion by another. This might include threats, harassment, or manipulation. If someone threatens to harm or blackmails another person into signing a document or a contract, for example, that would be actual undue influence. And an example would be in the context of wills. Undue influence occurs when someone coerces or manipulates the testator into making or changing the will which will benefit them, which is the influencer, or someone else, rather than representing the testator's true wishes. Normal influence through close relationships, however, isn't enough to overturn a will. It has to be undue influence sufficient to overcome the testator's violation. To prove actual undue influence, it must be shown that someone has actively coerced the testator into writing their will in a certain way. The next one is presumed undue influence, and this is where a relationship of trust and confidence exists between parties, and the person in the dominant position takes advantage of the other's vulnerability or dependence. A presumption of undue influence will arise. Relationships where trust and confidence arises include things like a parent and a child, maybe a doctor and a patient, or a solicitor and a client. The law presumes that the person in the dominant position may have taken advantage of the other person's vulnerability or dependence. The person claiming to be influenced doesn't need to prove the undue influence. They merely need to prove the existence of the relationship and that it was one of trust and confidence. The transaction should also call for explanation in the context of relationships. It's then for the person in the dominant position to disprove the presumption of undue influence by showing the other person acted freely and independently. And the case in regards to that is Lloyds Bank and Bundy 1975, where father mortgages farm under pressure from the bank and the court set aside the contract due to undue influence. The next element we're going to look at is illegality. So an illegal contract can affect any type of agreement or transaction. Not all illegality associated with contracts is equal. An illegal contract prevents claims based on contract where a person seeks to enforce an agreement which the law prohibits. The illegality operates primarily as a defense to legal claims. And that could be examples: contracts for criminal activities, contracts restraining trade unreasonably, and case of Pearson and Brooks, 1866. So a summary table identifies the definition of mistake, misrepresentation, duress, undue influence, illegality, and looks at key cases and the effect on contracts. So you can have a look at, we've gone through each one of them, but have a look at in the summary table. It's a brief outline of everything, so you can have a look at that in your own time. Thank you. So in conclusion, the principal factors that vitiate a contract are mistake, misrepresentation, duress, undue influence, and illegality. Address situations where consent is not freely given, and these factors will protect parties but also give the courts an idea of what is going on with the case, and the courts will need to ensure that the cases are based on fairness and mutual consent. 3.1 is outline various types of contractual mistakes. So in contract law, the primary types of mistakes are categorized as unilateral mistakes, where one party is mistaken; mutual mistake, where the parties misunderstood; and material, fact, and common mistake, where other parties make the same fundamental mistakes about a fact, rendering the contract void depending on the situation. The types of contractual mistakes, which we've gone through a little bit earlier on as well. So you've got mistake, common mistake, mutual mistake, and unilateral mistake. So common mistake, both parties share the same mistaken belief about a fundamental fact. And the effect on the contract can be void if the mistake makes agreement impossible to perform. An example: both parties believe have a car has a valid engine, but it's scrapped before the sale. Mutual mistake is both parties misunderstood each other, resulting in lack of agreement. And then contract is void and there's no true consensus exists. Cases Raffles and Wiltshire, which I spoke about a bit earlier on. And then unilateral mistake: one party is mistaken about a material fact and the other party knows of it or should know of it. And then the effect on contract may be void if the mistake is fundamental and apparent. Cases such as Haytog and Collins Shields, 1939, where the buyer exploited the seller's mistake in quoting prices per pound instead of per piece. So capacity to enter in a contract. Capacity refers to an individual's legal ability to enter into a contract. In simpler terms, it's a consideration of whether a person is in the right state of mind mental state and has legal capacity to commit a legally binding document. So, you need to make sure that the individual must have the legal capacity. So it could be minors, it could be people that have limited capacity. So the first one we're going to look at is minors' contractual capacity. So minors are permitted to enter into contracts for limited purposes. However, as the test whether or not they can focuses on the nature and transaction, whether the minor is of such an age that they are capable of understanding it. So, they need to, if they're under 18, the general rule states the contract entered into by child they are for necessaries are binding on children as those for apprenticeships, employment, education, and service, where they are rightly said to benefit of the child. Contracts for necessaries are for such things as the supply of food, medicines, accommodation, and clothing, but generally speaking, convenience in some products and services for comfort or pleasure excluded as commercial or trading contracts. These latter contracts are therefore voidable at the option of the minor. Consequently, whether the minor may avoid a contract they have entered into depends on the nature of the contract. And the case here is Nash and Inman, 1908. Contracts where the minor may avoid the effect of the contract are for acquisition of a legal or equitable interest in property or of a permanent nature. So shares, land, marriage, and partnerships would be included in here. Other contracts, however, require positive ratification in order to enforceable, which includes contracts for debts and the sale of goods that are not for necessaries. The ratification must take the form of an acknowledgement that the debt is binding after attainment at the age of 18. On the other hand, restraints of trade may be unenforceable against a minor, even if they would be enforceable against an adult. So, beneficial contracts are employment contracts which are enforceable and fair. The next one is mental incapacity and intoxication. Mental incapacity and intoxication contract refers to a legal agreement entered into by a person who lacks mental capacity to understand the terms of the contract due to intoxication, meaning they were drunk to comprehend what they were signing, potentially making the contract voidable or even void depending on the circumstances. So, for example, when a person is intoxicated, they are considered to lack the mental capacity to enter into a legally binding contract because they cannot fully understand the consequences of their actions. Generally, a contract made while intoxicated is considered voidable, meaning the person who was intoxicated can choose to cancel the contract once sober. For a contract to be voidable due to intoxication, though the party must have known or reasonably should have known the intoxicated person lacked the capacity to understand the contracts, and courts will consider the level of intoxication and the nature of the contract and whether the intoxicated person was taken advantage of when determining if a contract is voidable or not. For example, someone signs a large loan agreement while heavily intoxicated at a bar. When they are sober, they will be able to successfully argue that the contract is voidable because they were not mentally capable of understanding the terms when they were signed and because they were intoxicated at that time. So this is looking at tables of mistakes and minors, which we've gone through in more detail earlier, and minors with capacity, minors service, mental incapacity, and intoxication. So have a look at this in your own time, and it also looks at different case examples that you can use to help you identify certain concepts that we've gone through as well. So in conclusion, mistakes and capacity to a contract, especially involving minors, are critical, and the courts will look at this properly, and they would make sure that they have taken, whether the contract was a mistake, which type of mistake it was when the contract was made, was it a minor, was they intoxicated? So they want to try and protect the vulnerable people in the contractual relationship. So 3.2, outline different types of misrepresentation. So in misrepresentation in contract law refers to a false statement made by one party to another that induces them into entering into a contract, while a mistake refers to a misunderstanding or inaccurate belief that about a material fact of the contract, with different types, including which we'll go through, is fraudulent, negligent and innocent, mutual and common mistakes. So types of mistakes, we've got fraudulent, negligent and innocent mistakes. So fraudulent mistake is when a misrepresentation, is when a party knowingly makes a false statement with the intention to deceive the other party, intending them to rely on it to enter into the contract. Case for that was Derry and Peak, 1889, and the consequences is recession and damages for the deceit. The next one is negligent misrepresentation, and that's when a party carelessly makes a false statement without reasonable grounds to believe it's true, even if they did not intend to deceive. And the case of that is Headley, Bryan and Heller, 1964. And the consequences for that is recession and damages under Common Law or Misrepresentation Act 1967. And the last one is innocent misrepresentation, where a party makes a false statement believing it is true without an intention to deceive. So there's no intention here, and the rescission or damages is under the Misrepresentation Act 1967. So the Misrepresentation Act 1967, it governs the remedies for misrepresentation, what remedies are available, and what occurs when misrepresentation does occur. So, it is amended common law principles of misrepresentation to create a new category for negligence. So what damages and recession are available under the Act. Types of mistake we looked at earlier on as well. So in contract law, the types of mistakes we've got is common mistake, mutual mistake and unilateral mistake, and that diagram identifies them. So I'll just go through each one briefly again. When both common mistake is when both parties share the same mistaken belief about a fact that is essential to the contract. This can lead to a contract being void if the mistake is so fundamental that it changes the nature of an agreement. Then you've got mutual mistake, which occurs when parties to a contract are mistaken about a material fact, leading to a misunderstanding about the terms of the agreement. This can often render the contract void, as the parties were not truly meeting of the minds. And then unilateral, the final one, is when only one party to a contract is mistaken about a material fact, while the other party is aware of the mistake or should have known about it. This usually does not void the contract unless the mistake is very obvious or relates to a fundamental aspect of the agreement. So each one there's in that the diagram in the table has the key cases and effect on contract and what remedies are available for each one. The next one is looking at consequences of misrepresentation and mistake. So the element of that is the consequences are the court will allow rescission, which allows the party to cancel the contract and revert to the pre-contractual position, or damages under misrepresentation for fraudulent, negligent and innocent, and that would be dependent on each case and how it is judged. For mistake is a void contract, and in certain cases you get rescission, and equitable remedies rectification of the contract to correct the mistake. Excuse me. Excuse me. So in conclusion, misrepresentation and mistake both undermine the validity of contracts affecting the parties. The type of misrepresentation or mistake determines the contract and the outcome and what remedies available under the Misrepresentation Act, because the courts need to take that into account to make sure that everything is fair in addressing any sort of disputes, and also making sure that the affected party is treated fairly. So the courts have to take every individual case in its own merit. The next one is 3.3. So how a contract can be discharged. A contract can be discharged when parties have fully completed their obligations under the agreement, known as discharge by performance. or their mutual agreement to end the contract, discharge by agreement, which will include scenarios like breach of contract where one party fails to fulfill their obligations, making the other party free from their contractual duties, or when unforeseen circumstances make performance impossible, such as like the frustration, discharge by frustration. Methods of discharge we've got here. So the diagram actually shows you the elements of methods of discharge of contract. So the first one being by performance. So generally contracts end when parties have successfully fulfilled their contractual obligations to the best of their abilities. A discharge by performance occurs when all the terms and conditions are met satisfactory, which leads to the completion of the agreement, and this is known as a full performance. So this is where both parties agree, and the cases were Cutter and Powell, 1765, and the effect of contract is discharge parties free from further obligation. The next one is by agreement. So contracts may also be discharged if both parties mutually agree to release one another from the contractual obligations. There are two main scenarios that lead to this happening. First, neither party is able to fulfill their contract obligations, which is relatively a straight process, as both parties would generally agree to release each other from the contracts, as it serves both of them equally to do so. However, things get more complicated when one party has already fulfilled their end of the contract while the other party has not. So in such cases, a form of consideration is required in order to discharge the contract through mutual agreement. And the case in regards to that is British Russian Gazette and Associated Newspapers, 1933, and the contract effect on contract is discharged through mutual consent. The next one is through frustration. So through frustration is when unforeseen circumstances make it impossible to perform the contract, such as natural disaster or significant change in law. The contract can be discharged due to frustration, and that's the case of Taylor and Caldwell, 1863. And the effect on contract is discharged, neither party is at fault. And the final one is breach, which is if one party fails to fulfill their contractual obligations, this can constitute a breach, allowing the non-breaching party to terminate the contract and seek remedies. Case of that is the case of Poussard and Spears and Pond, 1876, and the case of Hong Kong Fair Shipping. And here the effect on contract, innocent party can terminate or claim damages, as we've just said. Next one is this. So we'll go through each one in a little bit more detail. Discharge by performance in the contract means the contract is terminated when both parties have fully completed their contractual obligations, essentially fulfilling all terms and conditions agreed upon, thus ending the legal relationship between them, is the most common way to discharge a contract. And key points here is the entire performance rule and the case of Cutter and Powell, and the exceptions in substantial performance if the party have substantially performed their obligations, and the case of Hong and Isaacs, 1952. The next one is discharge by agreement, and this is where both parties to a contract agree to end the contract or form a new contract. And types of agreement are things like mutual consent, mutual and release from consideration. So mutual consent is all parties agree to the discharge, and then release and consideration is parties can release each other from all the remaining obligations. The next one is discharge by frustration. Discharge by frustration is a legal principle that releases parties from the contractual obligations when an unforeseen event makes it impossible for the person to perform the contract. And it's the common law doctrine in English law that looks at elements of discharge in the contract. Doctrine of frustration discharges both parties from their contractual obligations, where the formation of the contract performance of contractual obligations become either impossible or radically different. And a really famous case in regards to that is the case of Taylor and Caldwell, 1863. In this case, the claimants had hired out the defendant's concert hall for 4 days at the price of £100 each day. After the contract was entered into, but before the day of the rental began, the hall was destroyed by the fire. The claimant could no longer host their concerts as a result of lost a significant amount of money. The claiming argued that the defendant should account for those losses, while the claimant argued that they could not be liable for accidental destruction of the hall. It was held that the defendants were not liable for losses. Lord Justice Blackburn held that there was an implied term in the contract that the concert hall would exist at the time of the contract. This implied formed the basis of the law frustration under the case of Davies Contractors Limited and Farham Urban District Council, 1956. And examples of frustration is destruction of subject matter, as we've just mentioned, illness or death, or government interventions. Limitation is self-induced frustration, does not discharge the contract, or mere inconvenience. Discharge by breach. Discharge by breach of contract means a contract is terminated because one party failed to fulfill their obligations under the agreement, essentially breaking the contract and allowing the other party to end the contract as a result of breach. This can happen if the party doesn't perform their duties, performs them poorly, or indicates beforehand that they won't perform as agreed in the contract. Key types of breach: actual breach, anticipatory breach, and the case of Hoscher versus DiL-Unit-Principles, 1853. Discharge by agreement. And this is parties may agree to terminate a contract either before or after performance. So you've got mutual discharge and release from consideration, which we went through a little bit earlier on as well. So this table looks at the types of breach: performance, agreement, frustration, with reference to what each one is, the description, and reference to key cases and remedies available and effects under contract law. So a contract can be discharged through performance, mutual agreement, frustration, or breach. Each method has legal specific implication and remedies, and when courts look at it, they will identify each one on the basis of the case, and this ensures protecting the rights of both parties and make sure that everything is fair. How lack of capacity, illegality, and public policy may void a contract. Illegal activity: an agreement to smuggle goods is a void contract because it involves unlawful actions. Lack of capacity is an agreement signed by someone who lacks capacity, and an agreement to sell non-existent voids the contract. So it could be illegal activity, lack of capacity, or impossible to perform the contract. So lack of capacity, the first one. Lack of legal capacity can make a contract void. For a contract to be binding, you need to fully understand and consent to an agreement. So a company must have corporate power to enter into. For instance, if you sign a contract with someone with advanced dementia, it would likely to be a void contract. So, you need to make sure that the contracts, if the person who's signing the contract doesn't lack capacity, because, it's really important that they understand what they are signing. And that could be anyone with minors, or anyone with mental capacity, or anyone intoxicated, as we talked about this earlier as well. Illegality. So illegality in contract law occurs when a contract is illegal or violates public policy. This can happen where the contract is created for an illegal purpose, or when the contract's performance becomes illegal. The consequences of illegality in contract law is the contract is void and unenforceable. Examples of this could be things like contracts to commit a fraud, gambling contracts. It could be contracts to involve a risk of gambling, or contracts involving unlicensed professionals. It could be bribery, it could be perjury, it could be obstruction of justice. Contracts prohibit, there is no question as illegality of the contract. So agreement made to evade taxes or any sort of illegal drugs or anything like that would make the contract void. The next one is number 2, which is on public policy. So public policy is a branch of contract law that addresses when a court will enforce a contract that violates public policy. Public policy is a set of societal expectations that most people agree on. So things like public policy is a collection of societal expectations, and it's social, economic, or political. It's not articulated in statutes or law. A public policy contract is a contract that violates public policy and is therefore illegal and or immoral. Examples of public policy contracts that restrain trade, contracts that prejudice marriage, contracts that use the jurisdiction of the courts, contracts to commit a legal wrong, and contracts that prejudice public safety as well. So, you know, the courts, you know, these are prohibited under common law on the grounds of public policy or morality. So they're immoral, as in the case of Pearson and Brooks, 1866. Anything interfering with justice as well is immoral. So public policy is the set of unwritten societal laws that all citizens must follow, you know, so it makes sure that, you know, it imposes limitations upon the freedom of persons to a contract. So it's really important that that is taken into account. Effects of void contracts. So we looked at lack of capacity, and the effect on contract is void or voidable depending on the circumstances. And the key cases is Nash and Inman, where minor was not bound for non-necessaries. Illegality, the contract is void and unenforceable. Neither party can seek remedies. The case of Reed, Mahmood, and Isfanrania. And public policy contract is void to protect societal interests. Parties cannot enforce terms in the case of Pearce and Brooks, 1866. Remedies for and outcomes. So you've got the outcome is usually that the contract is illegal and void. At law, the contract never exists. A form of restitution is ordered in many cases. Transaction can be unravelled, where the property is transferred back to the original owner before the contract was made. So there's exceptions. If one party is not at fault, courts may provide limited remedies. So it's really important to bear that for each individual case. Summary table and conclusion. Contracts can be voided due to lack of capacity, illegality, and violations of public policy, as we mentioned earlier. And the whole point of this is to protect you know, a society, but the vulnerable people as well, and uphold any societal norms as well, any sort of to prevent any sort of immoral agreements being formed in the form of drugs, or it could be in the form of, you know, money laundering, and to protect against any sort of public interest. So 3.5, how undue influence and duress may void a contract. So undue influence and duress can void a contract by undermining the principle of free consent, meaning that one party was not able to freely enter into the agreement due to the improper pressure or manipulation exerted by the other party, making the contract potentially voidable at the affected party's option. Essentially, if a contract is formed through undue duress or duress, the court may deem it unenforceable. So it's really important to identify that. So we're looking at the first one, which is duress. Duress in contract law is where one party uses threats or pressure to force another into a contract. A contract signed under duress is voidable or void depending on the circumstances. So physical duress is threatening to harm a person or their family or damage their property. It could be economic duress, threatening someone to cause economic losses to someone. An illegitimate duress, can courts assess the pressure applied was legitimate or illegitimate. You know, it could be threats to reputation, so threatening to defame or ruin someone's reputation. It could be threats to legal action, so threatening someone to criminally prosecuted or sue without legal grounds. Threats to withhold goods. This could be threats to withhold goods from someone. And the courts consider the seriousness of the pressure. Courts consider whether the pressure was illegitimate, and courts consider whether the pressure was a significant cause in inducing the claimant to enter into that contract. So, it's really important that the courts take this into account, because this could be where the person was forced into signing the contract through any sort of threats, coercion, or unlawful pressure, and it undermines the element of free consent, or this would make the contract voidable. The next element is undue influence, which we went through again earlier on in more detail, so I'll just go through it briefly with you. Undue influence is when one party pressures another into signing an agreement. The pressure can be subtle, such as leveraging information or creating a sense of obligation, and it could make it difficult for the other party to make a free and informed decision. Duress involves threats, such as blackmail or violence, to force someone to sign it, whereas undue influence can involve more subtle forms of pressure, such as taking advantage of a position they've got. So it could be actual undue influence, which is direct manipulation of a weaker party. So it could be a financial advisor, it could be a husband and a wife. And then you could have elements of presumed undue influence as well. And this could be a relationship, so it could be a parent and a child, pressuring the other type. And the burden of proof, is on the other party. So it's very difficult in this situation when we look at undue influence, what the law identifies it as. So, the element of it that is that you are forcing the individual because you are the stronger party. Cases in regards to that is the Lloyds Bank and Bundy 1975, where the father mortgaged his farm to secure his son's debt under pressure from the bank. The court held the contract was voidable due to undue influence. And the case of Alcord and Skinner in 1887, where a nun gave substantial gifts to a spiritual advisor, the court set aside the contract as undue influence was presumed due to their relationship. Undue influence in family and professional relationships. So the law presumes that the person in the dominant position may have to take advantage of the other person's vulnerability. The person claiming to be influenced doesn't need to prove the undue influence. They merely need to prove the existence of the relationship, that it was one of trust. So as we said, it could be in a professional capacity. It could be someone in a parent family relationship, could be someone in, the fact that it may be a husband and wife, or it may be a child and parent, a son pressuring his father or his, mother to transfer the property on their name. In a professional capacity, it could be the fact that, it could be an elderly parent, like we said, dependent on the child, coerced into changing the will, in professional capacity, it could be, it could be professionals who are trusting, like doctors who influence their, the patient who's maybe an elderly patient to do something, and sort out their finances. So, it's really important in regards to that, maybe put something on their name. It could be, commercial law, where a dominant shareholder in a company pressures minority shareholders into voting in favor of a merger proposal for the benefits of the dominant shareholder, or maybe a wealthy businessman pressures financially struggling individual to sign a contract for the sale of their property at a significant lower price than its market value by exploiting their desperation. So there's different elements of that you could consider. Effect on contract. So if a contract is formed under undue influence, it becomes voidable, meaning the party who was unduly influenced can choose to set aside the contract and not bound by its terms. Essentially, the contract can be legally nullified due to the lack of free consent from one party. So, they need to make sure that, a contract, key points to consider when it comes to undue influence and contract is a contract is affected by undue influence is not automatically void. but rather voidable at the option of the influenced party. The party claiming undue influence must prove that the other party used their position of power or trust to unfairly pressure them into entering into that contract. Factors considered, courts will consider the nature of the relationship between the parties. They will also consider the vulnerability of the influenced party and the terms of the contract when evaluating a claim of undue influence. And as we mentioned, it could be examples such as an elderly person being pressured by a caregiver to sign over their assets, or a business partner exerting excessive control over another partner in a contract negotiation, or a family member pressuring a relative to co-sign a loan with unfavorable terms. So it's the whole point of it is depriving the other one from their free will and consent. So the comparison of duress and undue influence is in the diagram there. While both duress and undue influence can render contract voidable, the key difference is that duress involves explicitly threats or coercion to force someone into a contract, while undue influence involves using a position of power or trust to unfairly persuade someone to enter into a contract, often without direct threats, but through manipulation or excessive pressure. Essentially, duress is more forceful form of undue influence. So it looks at the different aspects, and it looks at what duress is with reference to cases like Atlas, Express and Kafko, and Lloyds Bank and Bundy cases, and what the effect is on contract and the presumption. So the summary table also identifies the duress and undue influence with reference to the nature, examples, key cases, and the effects that you can have a look at in your own time. But both under duress and undue influence, the courts will consider the contracts as being voidable. So both duress and undue influence take away free will from the individual. So, they're depriving that person of their free consent, considering then the contract becomes void, or in some cases, undue influence can amount to criminal offences, such as fraud or abuse, unfairly ensuring any sort of pressure is put on the individual, and aggrieved parties have the option to rescind the contract and seek any sort of remedies. They act promptly and within the law. So, it's up to the courts how they identify a case, but the courts can consider the parties themselves and how vulnerable were they when doing this contract, and were they influenced by the other party for signing the contract, and the terms of the contract when the contract was part of it may be like changing of a will or anything like that, and this is where one party is forced. So they will take that into consideration, the courts, because they have to identify whether it was with the free consent of the individual and their free will and consent, rather than them being coerced to sign the contract. So what we've done now is we've finished learning outcome 3, which looked at elements of understanding the principal factors that may vitiate a contract. We looked at just a summary of what we looked at in today's session. So we looked at capacity to enter into contractual relations. We looked at minders' contractual capacity and contracts for necessaries. We looked at intoxication and intention to create legal relations. Meeting of the minds requirement. We looked at contract void on grounds of public policy, including prenuptial agreements, statutory illegality. Misrepresentation we looked at in regards to fraudulent, innocent and negligent misrepresentation, and looked at the consequences of each one with reference to case law as well to identify elements. We looked at Misrepresentation Act 1967, what the Act was there for, to protect individuals. We looked at mistake, different types of mistake, common mistake, mutual mistake and unilateral mistake, and the importance of that on contract law and what the remedies, if any, are available. We looked at the effect of mistake on contract and remedies again for the innocent party, and what the courts will consider when looking at misrepresentation and mistake in a contract. We looked at in detail on duress and undue influence, including things like family relations, professional capacity, and we looked at elements of examples of that in regards to how that would affect an individual as well. We looked at how undue influence may influence the parties, effect of the contract. We also looked at elements of remedies and outcomes available for the individual, and also looked at lack of capacity and illegality and public policy in regards to a contract being void. So that is just a summary of what we've done in today's session on Learning Outcome 3. The next session is Learning Outcome 4. References for Learning Outcome 3 are just there, so you can have a look at them in your own time. And the summary tables after each session is just to give you an identification of what we've been through each time we've been through each point. Preliminary, refer to any ebooks and journals on Moodle for this unit. There's a lot on there for you to refer to, and in the additional reading, I've put something on there that you can, it's a link to a PDF document on additional reading on contract law and vitiating factors. Any questions or queries you have, please email learnerwork@ukvarsity.co.uk. And any sort of queries or anything, and everything, ebooks, any additional resources are available on Moodle. This session is recorded and will be available for you. So like Learning Outcome 1, 2, and today's session, Learning Outcome 3. The next session we'll do is Learning Outcome 4. And thank you for attending today's session.